Yeah.
May I please, your Lord? I beg to mention, my Lord, transfer petition criminal 2022/2023. My Lord, I am for the respondent wife, my Lord. The matter was last listed on 34
Division
2020.
bench or single bench?
My Lord, single bench.
Yeah, please, Your Lordship. I beg to mention for listing of hearing, Met Appeal 30/2022. On
Hearing?
any date of hearing.
Any fixed date?
Any date of hearing to be listed on any date of hearing.
Make an application for the registration for hearing.
The petitioner is suffering from some multiple health complications, Your Lordship. The petitioner,
Use the mic.
Your Lordship, the petitioner is suffering from some with multiple health complications, Your Lordship, and the treatment provided to her is not sufficient in the jail, Your Lordship. Kindly report from the jail doctor may be called for, Your Lordship, and the LC has been received as per Office of Dated 24/24.
No, is there any application?
No, Your Lordship. There's an IA for bail, Your Lordship.
I for bail.
Yes, sir.
But have you expressed that he is suffering from something?
Yes, Your Lord.
Is there any specific statement?
No, Your Lord. But recently we have came to know that she is having some complication in the jail, Your Lordship.
Yes.
Your Lordship, recently we have came to know that she is suffering from multiple complications, Your Lordship. That's why I'm submitting before Your Lordship, so that a report may be called for from the jail doctor, Your Lordship.
Get a report. Heart, MS,
S. Nazneen, Your Lordship.
yes,
Nazneen.
Nazni. Learned counsel for the applicant appellant. And I have EPN. The applicant appellant is undergoing sentence pursuant to a judgment and order conviction and sentence dated 14/2000 passed by the signature Lima Hospital in section case number 57 2008. Sentence of life imprisonment. MS Nazneen learned passport application submitted that information has been recently received that the health condition of the applicant appellant is has deteriorated, needing urgent medical treatment. How old is he?
She, 40,
He,
yes, Your Lord.
lady,
48 years.
MS Mia, shall make an endeavor to obtain a report as regards the present health condition of the applicant appellant from the which jail,
You say Dima
from the
Hassan?
jail superintendent, concerned jail superintendent. Who?
Dima
No.
Central or district? I'm not sure about district jail.
district jail.
I'll verify my from the jail.
From uh, such report shall be obtained in consultation with the concerned jail doctor. List. How many days? 1 week?
Your Lordship, after receipt of the report from the jail doctor, I may be heard. After receipt of the report from the jail doctor, I may be.
Today is Monday, Monday I can obtain or on Friday. Seriously, it may be.
30. Friday
Please.
this bench find out
30.
Deeply apply.
300 for report. Okay, let it
After
come.
some time.
There was another, I think, appeal, right? We heard.
Yes,
Oh.
Sanjeev, but it was not shown as part heard, but it may be reflected in the order sheet. Sanjay does.
Is there- Yes.
Lordship, may I take your lordship first to the FIR, my lord?
Those we have seen, now the query is,
Issue.
the query is made by the court.
I'll still reiterate my submission, whatever I have made yesterday, lordship. The defense cannot take advantage of a situation when they did not confront the witness, my lord. So, lordship, that burden of proof will lie if the a witness is confronted with the particular fact in issue, my lord, that he was not a minor or she was not a minor, my lord. And in that event of the matter, if they cannot produce any material to that effect, lordship, then it will go against them.
The honors will save normally.
My lord. In a case, my lord,
When on a particular issue,
my lord,
knowledge is exclusively of the accused.
yes,
Suppose something has happened
my lord.
within the confines of a bedroom,
That's the point,
accused and another person is there.
lordship,
In that case,
My lord.
prosecution can prove
my lord,
whatever is possible,
my lord.
right?
My-
They cannot prove what has happened inside
Inside the
that
four corners
particular
of the
room, closed room.
My-
Then if the only person accused comes out
My-
without any injury, the other person suppose died, then it is for the accused to explain.
My-
Now, there is a case of that is not of that nature, right? Basically, age is to assert the age, to establish the age. It is not for the accused to, that honors
Which is
never
the-
shifts to the accused,
my lord,
right?
lordship,
So it normally lies with the prosecution to establish the age
my lord,
of the alleged victim.
my lord.
Now, what the prosecution has done is Assam Mazdoor or
Assam Sahmod Group,
Assam Mazdoor Students Association,
my lord,
Adivasi Students Association.
my lord.
Their office bearers, they do not know the victims, nor they know the accused.
Accused person,
So they cannot vouch for their age, victims' age.
Right.
Now, what remains are the two alleged victims and mother of one of the alleged,
lordship, yes,
right?
Right.
Because we cannot take their statement, this Adivasi Students Union office bearers testimony regarding their age.
Right.
Because they don't know them.
My lord.
They have clearly said. So, in such situation, what is the burden of the prosecution to establish
Lordship.
the age? That is what I am asking you.
Lordship, but one more factor, Lordship, the court cannot sit as a mute spectator. Under 165 of the Evidence Act also, court may put question to the witness concerned, my lord.
Hmm.
Whatever is relevant. And your Lordship, when the competency of the witness is tested, my lord, that is the satisfaction, for the satisfaction of the court, which was Lordship, the accused could, the witness could satisfy, my lord, that her competency was tested. Since she was a minor, my lord, that aspect your Lordship may consider. Since she was the minor, and according to the court also, she was a minor and her competency was tested, Lordship.
Is there any observation of the court below to that effect?
I don't think
Then-
regarding minority, minor.
Then petition appeal, how can it establish that the 165 is evidence?
Lordship, one more factor. May I see whether before after the investigation progress, whether the IO has taken any steps regarding the minority? Can I see your record? No?
Cool. We are confronted with issue of determination of
Age,
age.
my lord.
Positive finding has not been given.
Huh?
Positive finding is that not
No,
been
how then? How to?
asserted.
There is no presumption available. That presumption is not available for the court to
Lot-
draw.
lot.
Now, what is the way of establishing the age?
That under the Juvenile Justice Act, that will come
No,
into
we
play, Lordship.
cannot directly.
Lordship, then under 391, can your lordship exercise that power, the appeal stage also, to send the matter back?
Because they were not medically examined also,
No, I've seen the.
right?
case.
Their certificates were not produced.
No.
Age certificate or school certificate, those were not produced. Only that they have testified that I am 17 years or I am 12 years,
Lordship,
and mother has testified.
my lord.
Whether that is sufficient to
Because-
establish the age,
My
that is
lord. Yes,
what we are concerned with.
yes, but when the defense has not taken that plea, my lord, when the.
Oh, you are going to
The
again,
same way, same plea.
you are
I-
going back to same
yes,
thing.
same,
So
my
please,
lordship,
research,
lordship, my lord,
please submit
my lord. And
that
we
what
find-
is the
re-
requirement for the
re-
prosecution to do in such a case. That is what I am
Lordship,
asking.
so.
You are going
at
back to
this,
again,
yes, I understand, your lordship, because in
Because that
appellate
is not-
stage,
that might not be within that, within the special knowledge of the accused.
yes,
It
your
is
lordship,
within
but
the special knowledge of
Yes,
the prosecution.
my lord, lordship, but in the appellate stage, we are handicapped, my lord, being the prosecutor, my lord. Lordship, so in the,
Prosecutor was not.
because since
was
now, in
not
the trial
handicapped.
stage, they did not do anything, my lord. I have no other alternative but to go through whatever the matters
I'm
before me.
asking to be as an officer of the court,
Lordship, so the court
not,
should be
not as a public prosecutor.
Lordship.
Please, please,
lordship,
yeah,
my lord.
please.
I
There is
understand,
a
my lord,
difference
lordship's
between-
query. So under 391, can your lordship
is the-
exercise power to remand the matter back? For the end of justice, my lord. Direct, lordship may direct my to the learned court below.
On what basis the court will determine? So the IO has not collected the birth certificate for it.
No, at this, in the appeal stage also, your lordship may remand the matter back, call the person concerned and direct the parties to give additional evidence as regards the age, my lord. And the other party, the accused may be allowed to confront. You know, it's up to them to confront or not. If they fulfill the other criteria. If they are minor, my lord, the conviction and sentence will be different,
First,
if
we
they
have
are-
to reach
my lord. That,
something
yes,
on the age.
yeah, my
Whether it really comes under subsection 4,
My-
section 3, if it does not come, then automatically it will come to subsection 2.
My-
Paragraph number 25 of the judge.
Lordship,
There is material to the
evidence of the victim, I think
Paramananda. Whispered any word that
Paramananda,
PW word
treatment. Regarding that aspect, giving remuneration and all, my lord. Second line, the incident took place about 1 year. One day, accused came to our house asking boys and girls for doing domestic helper. Giving remuneration is not there for the accused persons ask them for taking them for work, that is it, for domestic work.
They said that there is fraud and steps.
Because in one of the witnesses also said for art labor work also they were taken, my lordship, evidence of PW2.
prosecution minor.
Charles,
Prosecution has brought the filed a charge sheet
Yes.
that victims were minor
yes,
and charges were framed
yes,
that victims were minor.
Minor.
Right? So out of the three, two were produced.
Right.
Now, Supreme Court has said that though the provisions of earlier rule, juvenile justice, is specifically referring to child in conflict with law,
law,
but that procedure should also be adopted in case of victim,
yes.
right?
Right.
So,
P. Yuvak Prakash judgment, latest
I
judgment.
I have found one journal thing.
P. Yuvak Prakash,
Supreme
my
Court.
lord, POXO matter, latest one. P. Yuvak Prakash. Latest
So
one.
there, what provision of CRPC you have been referring to?
Lordship, lordship, P. Yuvak Prakash judgment, the victim's age has, that factor has to be lordship, that she is the minor, that the victim is the minor. Your lordship, may I have a look? Latest judgment, 2020.
Because it is the burden of the proof of age, irrespective of whether it is by documentary proof or in the absence of such document via an justification case lies upon the prosecution to establish.
Lordship, may
Now,
I,
this burden is not discharged.
lordship, that is a special legislation, POXO. In,
Also is related to sexual offense,
yes,
prevention of whatever, but
Yes.
for age determination, we
I
are
know.
on the issue of age
age
determination.
determination. Right.
Now, whether if it is, say, child in conflict with
Law,
then the procedure to determine the age in the Juvenile Act is to be followed.
yes,
Now, Supreme Court has also said that in case of victim
Victim
also,
also,
that is
yes.
to be followed.
my lord.
Now, this whose burden is that? We are on to that.
Lordship, so under
This burden is
391,
to be charged by the prosecution.
my lord. So,
So,
instance,
to bring home a charge,
yes, my lord.
to bring home a charge, the prosecution has to establish its case that these victims are children,
Children,
and to establish that fact, prosecution has to follow certain procedure. Whether that burden has been discharged or not discharged, that is the
no, here it has not been discharged, my lord. So, under 391 also, at this stage also,
that is discussion.
for the edge of justice to both the sides, my
That is too late a day. And from the evidence of that boy, that does not indicate force, any application of force. criminal appeal under section 370 within bracket 2, comma, Code of Criminal Procedure within bracket court does unquote, or quote the quote unquote, comma, or court is direct against a judgment an order dated 12/8/2020 within the state of Assam, present time, bracket close, by the state judgment and order dated 12/8/2022, comma, the accused has been found guilty of the offense I need to understand guilty of the offense defined in subsection 5 of section 370 of the Indian Penal Code. Yes. Right. And he has been sentenced to undergo rigorous imprisonment for a term of 14 years and to pay a fine of rupees 5,000, comma, in default of payment of fine, comma, to undergo rigorous imprisonment, to undergo simple imprisonment for another 3 months. The case of the prosecution, comma, in brief, comma, was that investigation was set into motion on receipt of a first information report FIR from one Laxman Mali on 28/12/2016. So, in the said FIR lodged before the officer in charge of Saridwar police station, comma, the informant had inter alia alleged that at around 2 p.m. on 28/12/2016, comma, the members of All India, All Adivasi Students Association of Assam, Balipara unit, saw 3 children belonging to Adivasi community being taken away to Arunachal Pradesh as child labor by a suspected person. The person was questioned and 3 boys, after questioning the person and the 3 boys, the members of the association suspected something wrong, and the person along with the 3 children were handed over to Saridwar police station. Where, on receipt of the state FIR, the officer in charge, Saridwar police station, registered the same as Saridwar police station case number 199 stroke 2016, on 28/12/2016, for the offense under section 370 within bracket 5, IPC, and entrusted 1 Sri D.M. Sharma, a sub-inspector, no, and he himself took up the investigation of the case. Where the investigating officer of the case, investigating officer of the case, during the course of investigation, recorded the statements of witness 161, CRPC, visited the place of occurrence and prepared a sketch map after recording the statements of the alleged victim, that is, the 3 children. They were handed over to the Child Welfare Committee. The IO of the case, upon completion of investigation, submitted a charge sheet under section 173 within bracket 2, CRPC, by charge sheet number 21 of 2020. within bracket corresponding GR case number. Sorry, charge sheet number in connection with Saidwar Police Station case number 199/2016 within bracket corresponding GR case number 7029/2016 bracket close, finding a privacy case. For the offense under section 370 within bracket 5 IPC well established against the accused appellant. Where on submission of the charge sheet from additional chief judicial magistrate Sonitpur after upon appearance of the accused, furnish copies to him in compliance with the provisions of section 207, CFPC. As the offense under section 370 within bracket 5 IPC is exclusively triable by the Court of Sessions, the learned additional chief judicial magistrate, Sonitpur, Tejpur, committed the case records of GR case number 7029 to 2016, arising out of Saidwar Police Station case number 199 to 2016, to the Court of Sessions Sonitpur as per the provisions of 209, section 209, CRPC by an order of commitment dated 7/4/2018, and by allowing the accused to remain on previous bail, in the meantime. Also, on receipt of the case records of the GR case number 7029/2016, pursuant to the order of commitment dated 7/4/2018, the Court of Sessions, Sonitpur registered the same as Sessions case number 88/2018. On appearance of the accused before the learned within bracket Court of Sessions to Sonitpur, within bracket the trial court. On appearance of the accused person before the learned trial court, the learned trial court, after hearing the learned public prosecutor and the learned defense counsel upon perusal of the materials on record, framed the following charge. When the charge was read over and explained to the accused, he pleaded not guilty and claimed to be tried. So during the course of the trial, the prosecution side examined 7 number of witnesses, including Ayub Rakir and exhibit 4 number of documents. After closure of the evidence from the prosecution side, the accused was examined under section 313, CRPC, and his plea was denial. The defense did not adduce any evidence. After appreciation of the evidence on record and hearing the learned counsel for the parties, the learned trial court had convicted the accused appellant for the offense, mentioned above, and he has been sentenced in a manner, indicated above. We have heard Mr. B. Chakraborty, learned counsel for the accused appellant, and Ms. P. Poonia, learned senior counsel and additional counsel. Assam, assisted by MSM Chakraborty, learned counsel for the respondent state of Mr. Chakraborty, learned counsel for the appellant, has submitted that in the FIR lodged on FIR, FIR within EXT1 lodged on 28/12/2016, comma, he was not named as the informant who was informant as he was not known to the informant from any earlier point of time. He has submitted that the ingredients of the offense of topic, comma, define it, subject one of it, comma, are found absent, and in such view the matter, the accused appellant cannot be convicted as subject by 370 I, comma, as for conviction under subsection 5 plus for 375 more stringent conviction. One of the pardon, the prosecution was required to establish for an offense under section 5. I mean that the alleged victims were minors in the prosecution side. He has stated that the prosecution failed to establish the ages of the alleged victim in the manner prescribed by law. It is his further contention that out of the three alleged victims, comma, only two of them were examined by the prosecution. As such, comma, there was no evidence as regards the third alleged victim. Out of the two alleged victims which were examined by the prosecution, one of them had testified that he had voluntarily accompanied the accused appellant. The alleged second victim from the evidence of record, comma, it has emerged that the alleged second victim was then by her mother to a relative in National Party. That in the copy of the apple is entitled to be acquitted, and as the Senate trial court had hard in law to reach a finding that the aliens were minors and they were trafficked. They were trafficked. Were au contraire, MS when it topical has submitted that the members of the all Adivasi Students Association who testified as PW 1, PW 2, and PW 6 had testified that the accused appellant was intercepted when he was in the process of trafficking the three alleged minor victims. MS Mia has strenuously contended that from the evidence of from the testimonies of PW, a combined reading of the testimonies of PW 4 and PW 5 it was clear that the alleged victim, PW 4 was a minor, and there was application of force on the part of the accused appellant to take her out of her take her out from the guardianship of her mother, PW. So the fact that the accused appellant was with the three children, three alleged victims, finds corroboration also from the testimony of PW 3, who had deposed that he was who had deposed that the accused came to his house and took him along with the other two other released victims. Close. The act of apprehension of the accused along with three victims by the members of the association at a place which was at a distance from their respective houses of the said three children, goes to show that the prosecution has been able to prove, was able to prove, able to bring home the charge under section 370 to 5, comma. Anything more? Insofar as the age,
Trafficking part. No,
Age.
regarding
age
the age factor, my lord.
of the three victims of that obviously, it is the accused never taken a plea that the alleged victims were not mine.
My prayer that at this stage also your lordship for end of justice may exercise the power under 392. And to rely on one judgment. Not
As me as further referred to it.
2010 651.
The third is yes from the state that Jessica murder
Yes, my
within bracket NCT reported in 2010 661 to submit that yes which
para 188.
180.
That's
Just a minute.
47.
Yes. One 188, which part?
Subclause 47, my lord. Section 391 of the code is another salutary provision. It's closed.
Section para 1, para 46,
No, no. It would
Huh?
be
para
subclause
47,
188, 48.
48,
Para 188.
para 188,
There 47, my
47,
subsection. Subpara.
para 47.
Onwards, my 47, 48, 48.
To submit that this court as an appellate can exercise the powers under section 391, CRPC reasonably so that so as to find out the minority or otherwise of the alleged victim. We have given due consideration to the submissions of the party and have also gone through the evidence materials on record, including the testimonies of the witnesses available in the case records of Sessions case. I got it with 88 of 2018. The three prosecution witnesses that PW1, PW2, and no, two prosecutions, PW1 and PW2, were members where the president, where the president, where the then president of TNX Tea Garden Cell, Sunitpur district, and the then president of Assam. What is ASSA?
Will find in the FIR log.
Assam, all Adivasi Students Association of Assam.
Will find in the FIR.
Huh?
Lot will find in the
No, I
FIR.
have found all Adivasi students
Association of
Association of
Assam.
Assam. Double S does not appear. It appears. Double
Yes, my
S.
lord,
If you
Association of Assam.
abbreviate it,
My lord.
then whether there is double S. No, there is no double S. আগতে পাইছে না A A S A A A S A all some Adivasi students respectively. In their testimonies, from their testimonies, in their testimony, PW1 and PW2 deposed to the effect that they did not know the accused from any earlier point of time. Full stop. PW1 stated that on the date of the incident, he, PW2 and 3/4 others were at Palipara Center. They saw the accused along with the 3 alleged victims as X within bracket 12 to 13 years, Y within bracket 10 years, and Z within bracket 8 to 9 years. Names were not disclosed. It's not revealed for the purpose of that. Names revealed. The he testified that the alleged 3 victims, X, Y, Z, were belong to Adivasi community. So, when on suspicion, the accused and the alleged victims were confronted and they could know and it could be known that the accused was trafficking the alleged victims to Arunachal Pradesh for the purpose of labor work. Then, the all of them were handed over to Charidwar police station. In his cross-examination, PW1 stated that he did not know, he did not have any personal knowledge about the occupation of the accused. And in the affair, the name of the accused and the alleged victims were not mentioned. PW2. PW2's testimony was in similar was in similar line as that of PW1. of PW2. Deposed that on the date of the incident, comma, he, comma, PW1 and 3/4 others were at Balipara Center and they saw the accused along with 3 Adivasi children on suspicion, comma, they asked the accused and the children, they interrogate, and on interrogation, they came to know that the children were being trafficked to Arunachal Pradesh by the accused for the purpose of labor work. PW stated that it was he who informed the police over telephone. In his cross-examination, comma, he stated that he filed the SIR on suspicion narrating about the place. PW2 stated that at Palivara Center, comma, there used to be many shops and establishments, and there used to be public gathering. He further stated that it was after about 15 minutes it was after 15 minutes after he made the telephone call, comma, police personnel arrived at the place of movement. PW6, who was a contractor by profession, comma, deposed that he, on the date of the incident, comma, at around 12 o'clock, comma, he was at Palipara Center along with others who stopped. At that time, comma, they saw the accused with 2/3 children proceeding towards Arunachal Pradesh, Arunachal Road on foot. According to him, comma, the children were about 6 to 7 years old. When they inquired, when they made inquiry with the accused, comma, it was found, he replied that he was taking the children to Arunachal for study purpose. According to him, comma, the accused made an attempt to flee, and many persons gathered at the place of occurrence. So after informing the police, they were handed over to the police personnel of Saridwar police station. So, in his cross-examination, PW6 stated that police did not record statement. Well, PW3 was one of the three alleged victims. In his testimony, PW3 stated that the accused came to their house asking for boys and girls for to do works as domestic helper. So during that time, his parents were at home. So he stated that his mother allowed him to go, if he desired. Then, he went with the accused, who took him to Valukpu, within bracket Arunachal Pradesh. So PW3 stated that X and Z were X and Z were also with them. It was when they were coming out from a hotel after having tea at Valukpu, the members from ASA apprehended them and took them to the police station. When PW3 was cross-examined, he denied the suggestion that they were not taken by the accused to Bhaluk. He stated he disclosed his age as 17 years on the date of recording his deposition, 10/8/2000. PW5 is the mother of PW4, one of the three alleged victims within bracket death. PW4 was also examined on 10/8/2018, stated her age as 11 years. in her evidence in chief, PW 4 stated that on one day, the accused came to their house and requested her mother to allow the accused to take her with him for the purpose of assisting one child to go to school. Full stop. She further deposed that her mother, on being so requested, her mother, within bracket PW5, refused. Then, full stop. Then the accused told her mother, PW5, that he would pay remuneration. And thereafter, she was taken forcefully to a place full stop. The oh, no, full stop. X and Y were also there, full stop, like PW3, PW4 also deposed that when they were coming out from a hotel after having tea, the members of ASA apprehended them and took them to a police station. The in her cross-examination, PW4 denied the suggestions put to her by the defense. So, PW. It is relevant to mention that oath was not administered to PW4. So, after putting few questions and receiving answers to those questions, the learned trial court came to a conclusion that PW4 had sufficient ability to give rational answers. PW5. Was the mother of A of PW4 between bracket J. Deposed to the effect that on one day, about 1 year ago, the accused came to their house and requested her to give her daughter, Jade, for engagement as a domestic helper. So initially, she refused, but the accused forcefully took her daughter to Arunachal. It was when they were on their way to Arunachal, the members of the ASA intercepted and her daughter, X and Y were at the time of such interception, X and Y were also there. So the PW stated that the age of her daughter, PW4, it was about 11 years. When PW5 was cross-examined, she stated that she allowed her daughter, PW4, to go with the accused to one of her relatives' house at Arunachal Pradesh. So she stated that one of the said relative used to work at Arunachal. So PW5 further stated that the members of RASA intercepted the accused, her daughter, PW4, and others at Valukpung. Victims' family are saying they are at Valukpung,
Yes,
and these members are saying that Palipara.
Palipara Center,
Valukpung is a long
Park.
distance.
border.
When accused visited their house, one of the villagers was also with him. The eye of the case was examined as PW7. PW7 deposed to the effect that on 28/12/2016, PW two informed that one person was taking 3 children with him for the purpose of engaging them in works in Arunachal Pradesh. So on the basis of the said information, a general diary entry being CT entry number 937 dated 28/12/2016 was registered at 2:30 p.m. Thereafter, he along with staff proceeded to Balipara bus station to investigate into the matter. At Balipara GT Institute within bracket EXT 2. At Balipara bus stand, he found the person along with the victim girl and took them to the police station. In the meantime, he received the FIR in bracket. He received a formal FIR within bracket EXT1. So after preparing a sketch map within bracket EXT3, he recorded the statements of the victims and thereafter they were handed over to the children welfare. In his cross-examination, PW 7 stated that the accused and the victims were handed over at the police station. Where on a combined reading of the testimonies of the prosecution witness, comma, there was some inconsistency as regards the place of apprehension and manner of apprehension and the manner of apprehension. Full stop. The three prosecution witnesses, comma, PW1, comma, PW2, and PW6, deposed to the effect that the accused and the alleged victim were apprehended at Palipara Pass. On the other hand, comma, PW4, sorry, PW3, comma, one of the alleged victim, comma, and PW5, comma, the mother of PW, comma, another alleged, comma, deposed that the accused and the alleged victim were apprehended at Palu
When they came out of a hotel,
when they were coming out of the hotel after having PW1 and PW2 stated that after apprehending the accused and the three alleged victims, the matter was informed at the police station, and after being so informed, police personnel from Haridwar police station arrived at the place of offense. So on the other hand, BW7, the investigating officer of the case, deposed to the effect that the accused and the alleged victim were handed over to the police personnel at the police station. Subsection 1 has provided the definition, has provided for the offense of trafficking. So, as per subsection 1 of section 57, subsection 2 of section 370 provided for the punishment for the offense of trafficking, and as per subsection, whoever commits the offense of trafficking shall be punished with rigorous imprisonment for a term which shall not be less than 70, but which may extend to 18, and shall also be liable. Subsection 4 of section 70, 370 has provided for an offense where offense of trafficking of a minor. So as per subsection 4, where the offense involves the trafficking of a shall be punishable with rigorous imprisonment for a term which shall not extend 10 years, but which may extend imprisonment for life, and shall also be liable. Subsection 5 of section can be is brought in where the offense of trafficking involves more than one man. As per subsection 5, where both subsection 4 and sub 5 of section 7, IPC have provided for stringent punishment. So it is settled that the stringent is the punishment, comma, the higher is the burden for the prosecution to discharge. Higher is the burden for the prosecution to discharge. So in the case in hand, comma, the prosecution has brought the charge, had brought the charge that the accused was involved in the act of trafficking of more than one minor. Does, comma, para. Originally, when the FIR was lodged, comma, it was alleged that the accused was involved in the trafficking of three minors. During the course of the trial, comma, the prosecution had examined only two of the three alleged minorities. The one of the main burdens for the prosecution to prove to bring home the charge under subsection 5 of section 370 is to establish that the alleged victims were minors. When a question arises for determination of age of a child in conflict with law, comma, the provisions contained in the Juvenile Justice within bracket care and protection of children bracket close Act 2015 are resorted to it has been observed in Zarnail Singh versus State of Haryana, reported in 2013, 7 SCC 263, that even though the provisions contained in the Juvenile Justice Act and the rules framed thereunder are strictly applicable only to determine the age of a child in conflict with law, the aforesaid statutory provisions should be the basis for determining age, even of a child who is a victim of crime. So, such observation has been made by taking into consideration that there is hardly any difference insofar as the issue of minority is concerned, between a child in conflict with law, and a child who is a victim of crime. A reference to the provisions contained Section 94 of the Juvenile Justice Act 2015, according to the or short gives an insight as to how Gibson Gibson insight Gibson gives an answer to that question, and the gives an insight. Full stop. Wherever any dispute from a reading of the provision contained in Section 94 of the Juvenile Justice Act 2015, it is evident that wherever a dispute with regard to the age of a child in conflict with law, or a child who is a victim of crime, as the case may be, arises for consideration, recourse indicated in therein are to be taken. Full stop. The provisions have referred to three documents, namely, firstly, EIZ, first, the date of birth certificate from the school, or the matriculation or equivalent certificate from the concerned examination board, if available. And in the absence thereof, secondly, the birth certificate given by a corporation or a municipal authority or a panchayat, semicolon. And thirdly, and only in the absence of the document, two documents referred above, thirdly, age shall be determined by an ossification test or any other latest medical age determination test. The proof of age whether by way of documentary evidence of the nature indicated above, and in the absence of such document, by way of an ossification test, etc., lies upon the prosecution to establish, as it is the prosecution who brings the charge that accused is involved in an act, accused has committed an offense involving a child, involving a child who is a victim of crime, involving a child as the victim of a crime. So, in the present case, the prosecution has not brought on record any kind of documentary evidence from any of the authorities mentioned here in above, established the is that the two minors, the two alleged victims who had testified before the court, were minors, were minors. The prosecution side did not was silent as to whether any prosecution case or other age determination test was conducted at any time before uh, uh, it does go to show that there was the prosecution did not take the course to the procedure uh, the service to the procedure required to be followed for the purpose of establishing the age of the alleged victim. In the absence of any evidence, any documentary evidence as regards the ages of the two alleged victims, comma, it is, it appears, it does not appear to be safe to rely solely on the oral testimony is of the prosecution or three prosecution witnesses the PW court from the testimony of PW has not emerged that there was any kind of coercion or use of force or step on the part of the accused. There are, in so far from a combined reading of the PW4 and PW5, uh, uh, when when it is required uh, when it is required to weigh the testimonies of two witnesses on the same with one of as minor and the other is a major and more particular when there is the relationship of daughter and minor, comma, if the testimony of the major and the mother, which is the case and is PW5, comma, which uh, as a which is to be given a higher weightage. So PW5 from the test 5, comma, has emerged that she had allowed her minor daughter, comma, PW4 to accompany the accused who has to the house of one of her relatives, comma, who stayed in financial protection. We resume that we are to consider that the higher burden of proof, the prosecution which was required on the part of the prosecution to establish that the alleged victims were minors, was, can you was not found by the prosecution. With such evidence on material on record, this court, is not perfect to reach a view that the prosecution has proved discharged the burden beyond a reasonable doubt that the alleged victims were minors. To bring the alleged offense within the scope and ambit of either subsection 4 or subsection 5 of section 370, IPC. So, para. In view of non-discharge of the burden of proof required on the part of the prosecution to bring home the charge under either under subsection 4 or subsection 5 of section 370 IPC, what the scenario which emerges is that on the date of the incident, the accused was found in the company of the alleged victim at a public place, which was also not fully established whether it was Balipara bus stand or Haluk, in view of conflicting versions of the prosecution witnesses as PW1, PW6, and the prosecution witness as PW3, PW5. the if if, it is accept that on the date of the incident, Peter it is assumed accept that on the date of the incident, actual the accused and was 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 on the date of the incident was was found in the company of the three alleged victims at a public the same could not go in the absence of any other opposing and credible evidence that the same could the ingredients of the offense under section 3. The accused and the three alleged victims, finding the accused and the three alleged victims roaming at a public place, the members of the ASA associate, ASA, without who did not know either the accused or the alleged victim from before, seem to have acted as vigilante and apprehended all of them merely on suspicion, and thereafter handed them over to police. But there was no complaint of any nature from the end of either the alleged victim or from the families of the state alleged victim. Even the testimony of the PW and PWP, the testimony of the PW and PWP are analyzed vis-a-vis the testimony of PWP, who claim have intercepted the accused and the alleged victim at the same time, and also their testimonies were found authentic. While PW1 2 stated that when interrogated, they they got to know that the alleged victims were taken to Arunachal Pradesh for the purpose of labor work. The third witness from my PW stated that when interrogated, he got to know that the alleged victims had been taken to Arunachal for the it is settled that people of this criminal justice and it is settled that prosecution has to, in order to bring home a charge for an offense, it is its burden to discharge it beyond all reasonable doubt. From the respect made above and the finding recorded hearing, clear the possibility that in the case in hand to establish any case of stepping beyond all reasonable doubt. It is also settled that benefit of doubt, other things being equal, at all place goes in favor like does, in the case in hand, the benefit of the accused like is entitled to the benefit of is entitled to the benefit of accordingly, this criminal appeal is found merited. Accordingly, the same is allowed by interfering with the judgment order created to ensure the standard trial. He is in jail or
He is in jail
he is in
custody.
custody? As the criminal appeal order of conviction is entitled with the accused to be set at liberty forthwith, if he his custody is extended, his custody is not required in connection with near. But don't expect to get it today.
Like,
And another point, my lord, that since Is a minor are competent.
That we have dealt with, that is oath,
Right.
but not admission. We have dealt with when on the same issue, the minor and the major who are in the relationship of daughter and mother, then higher weight should be given to the mother. We have already dealt.
Unattended is
Yes.
correct.
Yes.
Hello. Let us find out what has fallen from the horse's mouth. That is the victim's mouth.
My lord.
Because in this case, other evidence would be hearsay evidence, right? Mother or father, they may say about pre-occurrence and post-occurrence, right? So, in between what had happened during the period of alleged detention, that has to be from the horse's mouth.
Yes.
The horse is the victim
Right.
because whatever had happened
Well.
during that detention, he may say so to his mother or police or father, but their evidence would be in the nature of hearsay evidence.
Yes. Correct. My lord.
We are hearing this with a view that we may not be able to conclude it today because we have to speak in the single mention. Yes. Who is he?
Yes, my
PW.
PW5, my lord. Before that, only one, my lord, date your lordship will take note of, because the date of judgment being 14/11/19. By this time, my
Right.
lord, the appellants, my lord, are behind the bar, imprisonment for more than 4.5 years. So this could be a relevant lord, factor. So that is why, my lord, I am pointing out to your lord.
Your alternative submission.
Uh,
Alternative
If
submission.
eventually I don't, my lord, succeed.
Alternative.
My lord.
Conviction on?
My lord, 364A.
No. Date.
Date, my lord, 14.
14.
11/19. Date of judgment.
So about 4.5.
4.5 years.
It is reflected in the causes itself.
Was it
4 years, 5 months, 8 days. It is calculated. And on that basis, we are giving precedence.
my lord, correct. My lord will come to PW, my lord, 5. In the paper book, my lord, it is page 25, my lord.
Yeah.
Deposition of PW5, aged about 17 years, taken in oath or solemn affirmation. The name Amit Nair, father's name Dulal Nair. May I read, my lord? I know the two accused persons present in the dock. One of them is Ram Prasad Biswas, and I do not know the name of the other accused. Accused Mahadev Das, Sanjoy Das, Dipankar Mallik, and Tapas Mallik are absent today
Now,
my lord.
who are the
Yes, my lord.
appellant here?
Exactly, my lord. I was going to refer to that.
Ah.
My lord, the appellants are three convicts, my lord. They are
Where is the judgment? How they are styled?
Yes, correct.
So that who is one, two? Sojal Biswas.
My lord.
He is one of the appellant?
No,
Where is your appeal memo?
Yes.
113. Okay, Sanjoy Das.
Yes.
Okay.
my lord. If I indicate, in fact,
It is 113.
yes, correct. My lord, Sojal
Ram
Biswas,
Prasad. Ram Prasad. How many accused were convicted?
my lord, these three persons, appellants were convicted.
Okay.
Sanjay Das, Dipankar Malik, Ram Prasad Biswas. Now, Sojal Biswas, my lord, he was acquitted by the trial court.
1 minute. Where is the judgment?
That your lordship will find at page 81 of the paper book. Last, my lord,
Okay.
the penultimate paragraph.
Sojal Biswas.
My lord.
Dipankar Malik, Sanjoy Das, Ram Prasad Biswas.
Biswas.
4 accused stood the trial.
Mal. Mal.
Out of that, Sojal Biswas was acquitted.
Acquitted.
Okay.
And one, my lord, Mahadev, he was, my lord, the accused in the affair, but he was declared as an absconder. Mahadev. So the trial was split, my lord.
Okay. Great.
Yes.
And there was another boy,
Another boy, my lord,
juvenile.
juvenile.
Where is it mentioned in the judgment?
Yes, his name is there, my lord. If your lordship comes to page 81,
81.
yes, my lord. Second para, 5, 6, sixth line from the top, my lord. Here in this case, Tapas Malik, who was declared juvenile,
Okay.
that this is Tapal Mos.
Reflected in this
69.
second paragraph.
Okay.
Support not
Okay. 1 minute. Tapos Malik. 1 minute. Tapos Malik was juvenile. Right?
My lord.
Then who was absconding?
He was my lord Mahadev.
Mohadev. Huh?
নহয় নহয় নাই 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 সেইটো নহয় দীপঙ্কৰ মল্লিকটো হেৰি হৈছে না he is the appellant. He has been convicted. Subsequently, he appeared all along, my lord.
Okay,
Mahadev.
no, who was declared absconding?
Mahadev, man.
Mohadev.
Mahadev.
Mohadev, what is his surname? Surname?
My lord, I'm coming to that. Mahadev Das.
Das.
Das. Mahadev Das, son of Anil Das.
Absconder.
My lord.
So split.
Split, my lord.
Okay. And who was acquitted?
Acquitted, my lord. Sojal Biswas.
Sojal Biswas.
So three convicted, my
One.
lord. Dipankar Malik, Sanjoy Das,
One
Ram Prasad.
Accused. Oh, sorry. Acquitted. Acquitted. And who are the appellants there?
Appellants, my lord,
113.
yes. All the three, my lord. Convict three, my lord.
Sanjoy. And Dipankar Malik.
My lord.
And third is Ram Prasad.
Ram Prasad Biswas.
Yes. Yes, you
May I
can read
request?
now. Yes.
I know the two accused persons present in the dock. One of them is Ramprasad Biswas. I do not know the name of the other accused. Accused Mahadev Das, absconder. Sanjoy Das, Dipankar Mollik, and Taposh Mollik are absent today. Informant Dulal Nayak is my father. About 11:30 a.m. on 9/5/2010, I went to Shishu Kalyan High School, Bijni, from my house on a bicycle to see Robindra Jayanti celebration. Taposh Mollik came across me on the way and he asked me not to go to school and to go along with him to Anamika studio near Bollamguri bus stand to download songs on mobile phone. I went there, but since power supply was not available, songs could not be downloaded in the mobile phone. Thereafter, we got our hair dressed in a salon. Therefrom, Taposh Mollik took me to Saitanguri. There was jungle near the place. There I came across Mahadev Das, Sanjoy Das, and Dipankar Mollik. Then Dipankar Mollik took my bicycle and left for purchase of betel nut. After Dipankar came back with the bicycle, Dipankar took me to the jungle. There, Mahadev, Dipankar, and Sanjay asked me not to shout and accompany them. When I asked why I should go with them, Mahadev and the other two accused told me that they would demand amount of rupees 1 crore from my family for my release. After keeping me in the jungle during the day hour, Mahadev took me in the evening on a bicycle to the house of accused Ramprasad Biswas at village Bishnupur. At Bishnupur, Mahadev demanded an amount of rupees 1 crore from my father over a phone call made from mobile phone. I talked to my father. I stayed the night in the house of Ramprasad. On the following day, I was again taken to the jungle of Vishnupur, but since elephant roamed the jungle, I was again brought to the house of Ramprasad. I stayed in the house of Ramprasad for 3 days. On the following day, police recovered me from the house of Ramprasad. Then accused Mahadev, Sanjay and Ramprasad were with me. Accused Dipankar was not there at that time. Taposh had left earlier. Later, I told these things to my father. After recovering me, police took me to the PS. Police produced me before magistrate at Bijni Court. Magistrate took my statement. Exhibit 4 is my statement. Exhibit 41, 42, 43 are my signature. Police questioned me. So this is the script. Now cross, Malon. The phone call was made to my father from the jungle of Bishnupur. The phone call was made in the following evening. The accused persons had the mobile phone number of my father since before. When accused Mahadev took me on a bicycle, I did not scream. Except Ramprasad and his wife. No other person was there in his house. I was not allowed to talk to Ramprasad's wife. There were houses of other families near the house of Ramprasad. The village of Ramprasad and ours are different. I do not know Ramdas, wrongly said Ramprasad, from earlier. I talked to my father in the evening on the following day. I also talked to my mother. I said that I was kept confined. Tapas and I read in the same class but in different schools. I come across Tapas alone. I do not come back to the house after getting my hair dressed. It is not a fact that I paid a visit to the house of Ramprasad and that he did not take me, thereby applying force. It is not a fact that I was aged more than 17 years at the time of the incident. It is not a fact that the statement that the accused persons demanded an amount of rupees 1 crore from my father is false, and that they did not demand an amount of rupees 1 crore from my father. After taking me to the PS, police allowed me to go to my house with my father. After staying for the night in the house, my father took me to the court on the following day. It is not a fact I gave statement before the magistrate the way I have been taught by my father. It is not a fact that the accused person did not commit any offense and that they are in.
Father,
Father PW1. Page 12 of the paper.
Yeah.
Now, the deposition of PW1. The name of my son is Amit Nayak. The incident took place on 9/5/10/2010. He was aged 15 years then. He was reading in class 10. The incident took place about 11:30 a.m. that day. That day, my son went to Bijni Shishu Kalyan High School. He went to the school alone on the occasion of Rabindra Jayanti. When I was heading home, I came across him on the road. Since my son did not return home till evening, we asked his friends about him. He did not return that day. A boy said that he had seen my son at Anamika Studio, Bijni, and that Tapos alias Bhavna was along with him. I do not remember who told me that. When I went to Anamika Studio on the following day, the owner of the studio, Harlal Rai, told me that my son had gone to his studio with Tapos. Tapos' house is situated near my house. I went to Tapos' house, and when I asked Tapos, he told me that he and my son had left each other in the market. Then first I verbally informed the PS of the incident, and thereafter I lodged an FIR with the PS. Exhibit 1 is the Azahar, and Exhibit 1-1 is my signature therein.
where is that? Is it one?
Yes,
That was on 13/5.
that was 13.5. It's a second FIR, Exhibit 1, because there is a GD entry also, pursuant to the first FIR.
Okay.
Then Exhibit 1 is the Azahar, and Exhibit 1-1 is my signature therein. Around 7 p.m. on 10/5/10, someone made a phone call to me from mobile phone number so-and-so and told me over phone that they were terrorists, that they had kidnapped my son, and while demanding rupees 1 crore for the release of my son, the person said that they would send the dead body of my son to me if the demanded money was not given to them. I told my friend Narayan Sarkar about it. Narayan went to PS, taking my mobile phone with him, told police about the matter, and showed the mobile phone to them. 2 days later, another phone call was made to me from said mobile phone number, and on that occasion, an amount of rupees 95 lakhs was demanded. On 13/5/2010, I was informed over a phone call made from Bijni PS that my son had been recovered. When I asked my son, he told me that Tapos had taken him away and handed him over to Sanjay, Mahadev, and Dipankar. Exhibit 2 is my statement recorded under 164 CRPC in the Honorable Court. 2-1 and 2-2 are my signature.
Now let us
Yes, then cross my. I am not aware as to whom the mobile phone number I have mentioned above belong to. Accused Tapos Malik was a friend of my son, and classes and schools they read in were different. Accused Mahadev hails from my locality. I am acquainted with him. While talking with me over phone, they did not mention that they were terrorists. They talked to me in Assamese. After receipt of a phone call on 10/5/10, I did not lodge the written ejahat with the PS. My son went to Harlal's studio to load songs. Harlal told me that another boy went to his studio with my son. Narayan went to the PS taking my mobile phone with him and reported the incident to police. Police did not seize that mobile. I am aged 44 years and I do not have property worth rupees 1 crore. I lost a written ejahat with the PS on 10th day of the month. I lost Exhibit 1, the ejahat, after the recovery of my son on 13th day of the month. I do not know from whose house, under what circumstances, and how police recovered my son. It is not a fact that the accused person did not kidnap my son, that he went to visit some place and that police recovered him. I made my statement under section 164 CRPC in the court 1 or 2 days after recovery of my son. I stated in Bengal.
Let us read the FIR.
FIR, my lord, at page 4. Here it is addressed to the officer in charge, Bijni Police Station, by my lord informant Dulal Nayak, and 5 names, my lord, are mentioned: Mahadev, Dipankar, Tapos, Sanjay, Rampasan. Sir,
Fazol Biswas was missing.
Yes.
Fazol was not named.
not named, ma'am.
Let us read.
Here it says accused 1, 2, and 3 are resident of number 2 Saitangudi. Accused number 4 is a resident of Monesori. Accused 5 is a resident of number 3 Vishnupur. All are under Bijni Police Station in the district of Chirag. Sir, humble submission is that my minor son, Sri Amit Nayak, aged 15, had gone missing since 10 a.m. Of 9/5/2010, Sunday. I lodged an ejahat with Bijni Police Station on 10/5/2010, Monday. Around 7:50 p.m. that day, some unknown person phoned me using the mobile phone number so-and-so and demanded rupees 1 crore for the release of my son, and also threatened me that in the event of my failure to pay the said amount, they would send my son's dead body to my house. After I had informed said incident to Bijni Police Station, the police carried out an investigation into the matter and recovered my son from the house of accused number 5, where he was kept confined by the accused person. Police also found the above named accused person in that house. I therefore pray to you to give the recovered body to the custody of the informant and take necessary action against the accused person by investigating
It was after recovery. The fire was after
after
recovery.
recovery.
And what happened to this written ejahat lodged on 10/5,
That is, my lord, not activity.
not exhibited, no GD entry.
No, there is a GD entry mentioned by the IO. If your lordship comes to the evidence of the IO, my lord, 51, no? 41. 41, my lord, of the paper book. PW 11 is the, my lord. On 10/5/2010, I was on duty in Bijni PS. The OC of the PS made GD number 244, dated 10/5/2010, on receipt of a written information that a 15 years old boy by name of Amit of village Ganeshwari had gone missing and entrusted me with the task of its investigation. So investigation started pursuant to the GDNP.
Let us see exhibit 10. Exhibit 10.
Well,
No, page 44. On oath. Exhibit 10 is the GDN. Number 240. It is exhibited, but not part of the paper book, perhaps.
It is a
into control.
Might be hit by 162. Second affair.
lordship.
How detailed is the written information?
Exhibit 10.
What do you say about this GDN 244,
Well,
dated 8/5/2010?
Well.
IO had deposed that he started investigation on the basis of GDN. Right? Thereafter, recovery was made. Thereafter, FIR was launched. FIR was with a prayer that please hand me over my giving a detail. So, what do you say about this FIR and GDN?
my lord, my submission is it relates to the same offense. I'll, my lord, place some judgment after PT
Will
Antony.
be-
Yes, yes, my lord, regarding this consequence.
Shortly,
The consequence, my lord, sameness of offenses. The Babu Bhai, it has been, my lord, not to be aware, it has been discussed. So once, my lord, having the investigation started, the second FIR will come under 162, my.
I don't find exhibit
Yeah.
8 here.
And if your lordship
List of
comes to 84,
exhibits.
this is not an
Right, sir.
exhibit. Exhibit 10 is the charge sheet. If your lordship comes to 84 of the judgment,
no, page 44, exhibit 10 is a GD entry.
page 44.
I have read it from the page 44 of the paper book.
My lord.
On oath. Is it not? Charge sheet is exhibit 9.
Maybe in the case that
Because informant is because the written
Written. He himself.
ledger. If that is detailed, if that is detailed, so there might a question might arise that the exhibit 1 could be the second affair, and it might be hit by section 1.
160.
As simple as that.
Yes.
Let us have a look.
10/5/20.
10/5/2010. If it is cryptic, then it will be different.
Lordship, it's there. Particular. অপৰাহ্ন 12 বজা ল'ৰা হেৰুৱা দৰজ। এতিয়া সত্ৰ থানাৰ নিবাসী চিদুলাল পিতা অজ্ঞাত মনেশ্বৰী থানা, বিজনী জিলা চিৰাং, BTAD অসমে থানাত এখন লিখিত দৰখাস্তযোগে জনাই যে যোৱাকালি ইংৰাজী 9/5/2010 তাৰিখে তেওঁৰ ডাঙৰ ল'ৰা শ্ৰী অমিত নায়ক বয়স 15 বছৰ ক্লাছ 10মান শ্ৰেণীৰ ছাত্ৰ যোৱাকালি তেওঁ দুপৰীয়া ৰবীন্দ্ৰ জয়ন্তী অনুষ্ঠান চাব বুলি ওলাই গৈ ঘৰলৈ উভতি নোহোৱাত কোনো ধৰণৰ খা খবৰ বা সুংসূত্ৰ পোৱা নাই মতে জনোৱাত ঘটনা তদন্ত কৰি এই বিষয়ে WT মেছেজ যোগে অল কনচাৰ্ণ জনাই দিবলৈ যত্নবান থাকি পঞ্জী দৰজ দি ৰখা হ'ল। উক্ত এছ শইকীয়াৰ অনুসন্ধান কৰি বিহিত কৰাৰ কাৰণে নিৰ্দেশ দিয়াৰ নিৰ্দেশ দিয়া হ'ল।
First one. Do you have any idea? It is not in the activity. That was not exhibited. You may find.
Right.
Mother? Mother?
Mother, my lord, PW2.
Hmm.
One five.
Anything? So, this is not the one. This was 13.5. Mother?
Mother, my lord, PW2.
Hmm. Anything?
short,
In-
my lord. May I read it?
Yes.
She is, my lord, Priyalata Nayak, housewife. It was taken on July 2011. Amit Nayak is my son. Dulal Nayak is my husband. The incident took place on 9/5/10. At that time, my son was reading in Bijni Shishu Kalyan High School. He was aged 15 years. It was the occasion of Ravindra Jayanti that day. That day, he went to school in between 10:30 a.m. and 11:30 a.m. I told him to come back at 12 noon. I did not. He did not come back. He did not come back to house that day. Since he did not come back, I asked my brother-in-law, Kamal Nayak, over phone whether my son was with him. My son was not with him. At about 5 p.m., when my husband was informed about the matter, he came to the house. I made inquiry in the house of accused Sanjay. A younger brother of the said accused is my son's classmate. I do not know his name. He told me that he did not see my son in the school. Another boy told me that he had seen my son with accused Tapas in Anamika studio. I do not know the name of the boy. At about 8 p.m. on 10/5/10, accused Mahadev told us over phone that they had kidnapped my son and demanded an amount of rupees 1 crore. Otherwise, they would kidnap my nephew, Gaurav too. He did not disclose his name while talking over phone. I learned it later. On 13/5/10, the police informed us that my son had been recovered. My husband went to the PS. He came to the house around 7 p.m. When asked, my son said that he had gone with Tapos. The Tapos had a haircut and that thereafter they went to see football match at Soitanguri. He said that thereafter Tapos had told him that he would call someone. That Tapos had asked him to keep waiting there and that then taking his bicycle, Tapos had left. My son said that Tapos had not come back, that another boy had brought the bicycle and that he had been handed over to accused Mahadev, Sanjay, Dipankar and Ramprasad. He said that the 4 persons kept him in the jungle and brought him to Bishnupur in the evening. Later, police recovered my son from Bishnupur. Cross. I have stated on the supposition that Mahadev Das had made the phone call. That day, my son did not go to school to see the Ravindra Jayanti celebration. I do not know as to from whose house police recovered my son and how. Accused Dipankar is not present in the court today. Accused Mahadev is our neighbor. We have no enmity with him. Today I have adduced evidence in the court upon hearing the incident from my son.
Who is Narayan Sarkar?
Narayan Sarkar, my lord, he is an independent witness. That father of my lord,
Neighbor.
Yes.
Neighbor.
my lord, the friend of the my lord father, victim's father, and he had taken his name in his evidence that he also accompanied him to the police station, my lord. Narayan Sarkar.
So to bring it within the ambit of 364A, firstly, two ingredients are to be proved. One is kidnapping or abduction of any person and or keeping him in detention after kidnapping or abduction. First one.
Well.
So that also comes within the other kidnapping.
Well.
Secondly, there should be threat to cause death or to hurt to such person, means the person kidnapped, or by his conduct give rise to a reasonable apprehension that such person, meaning thereby kidnapped person, may be put to death or hurt, or causes hurt or death. Now here there is no hurt or hurt caused to the kidnap. Or no? or by his conduct gives rise to a reasonable apprehension that the kidnapped person may be put to death or hurt or causes hurt or death to such person in order to compel any other person to do or abstain from doing or to pay ransom. So here that the other person, meaning thereby the father or the mother, they should be put
Yeah.
to a reasonable apprehension that the kidnapped person will be put to death
Yeah.
or hurt, will be caused hurt,
Mm.
right?
Mm.
And to pay ransom. Now, this threat or reasonable apprehension may arise or may be established from two angles. One is by from the mouth of the kidnapped person or from the other person who was asked to pay the ransom. Here it is the case, mother or father. Now, whether they have been put to such apprehension or not, there were telephone calls demanding ransom, otherwise dead body would be handled. Now, whether that fulfill the ingredients, the evidence on record, that is the issue.
That is right.
Now, what are the other exhibits?
That GT entry has been shown as exhibit 10.
Ah.
The part of find it.
What happened to that FIR?
Just missing my
Based on that
shit.
See, this FIR was, the exhibited FIR was submitted after all the things that happened. After
And the last-
recovery of the kidnap board. So that there is vital significance what was there in the first FIR.
Yes. That book is there, Lordship, but I couldn't find the FIR.
And who exhibited this?
EW 11, my
No. Exhibit 6. What is Exhibit 6?
Caesar list.
scissor list.
See, Caesar list 94. That the mobile was seized on 10/5/2010. Two SIM cards were seized. 3. 3 SIM cards were seized on 10/5/2010. Then again, by another seizure list, page 96.
On Sony Ericsson.
Oh, no. It was not, sorry, it was seized on in Okay, okay, Mr. Taludar,
Well-
down to page 90.
94.
Read. These are all prior to lodging of FIR. Please read
Well.
loudly.
I, SI, SM Soikia of Bijni PS District, Iran, do hereby seize the following descriptive articles from the
Possession of
possession of accused Mahadev Das, Sanjoy Das,
hmm,
Ram Prasad Biswas,
hmm. With the above reference. Above reference is GD entry 244.
Yes.
Dated 10/5/2010.
10.
In presence of the below signed witness,
witnesses.
the seizure made at number 3 Vishnupur village on 13/5
13.
at 6:20 a.m.
Yes.
Right?
Hmm.
Then come to base 96. One Arun Sinha.
Yes.
Another SIM card
Another
on 13/5.
descriptive one
Right.
is for one thing. Presence below signed witnesses. Vishnupur Bazaar, yes. Sony Ericsson model for so and set right for along with one Airtel SIM card.
Okay.
No.
And provision of 65B is inserted in 2000. 17/10/2000. Whether it is material exhibits were exhibited. Phone of the Mahadev Das, high-tech mobile handset. That could be primary evidence, primary document. Exhibited.
There is one material exhibit.
What?
Material exhibit 1.
As a
My lord.
Where?
PW7 says,
PW7.
yes, my lord. And that belongs to, my lord, it was seized from one, that PW7 Arun Singh. He is not an accused, but
So what?
he is a witness, my lord, not an accused, but he says that it was seized from my house.
No, that is 96, page 96.
The evidence of PW7 at page 33.
33.
No, that relates to page 96.
That is the material exhibit.
That is a Sony Ericsson mobile.
Yes.
Along with one Aircel SIM card. And that belongs to, that was produced by Arun Singh. Now who is Arun Singh? What he has said about it?
PW7, my lord, page 32.
What he said about it? That mobile was taken by Sojol.
Yes.
Now MS Bhuya,
Yes.
the victim had never deep that he was put to any threat. So the other evidence
Yes.
deposed by other his mother or father or his uncle post occurred, post recovered, were all on the basis of the kidnap. That is omit. So whatever they have deposed, all would be in the realm of error. So when the kidnap did not say that I was put to reasonable apprehension that I will be hurt, I will be so and so if the money is not demanded. He had never said that, and he said that I talked with my mother, I talked with my father. Never say. but something was put to him by the mother and father
My lord.
that his dead body would come if we do not give one proof. Now, and whatever they have said, they said on the basis of a phone call allegedly made by Mahadev Das. Now, how do you connect that? Because their son is not saying. Okay. Good, right?
That trick part I'll see, but it's not there at the face of it, not there.
So far, from the mouth of the kidnapped boy, nothing has emanated that he was put to reasonable apprehension that he would be hurt or put to death, right? He said something that yes, the others have said that money would be demanded from your parents. That is what he had said.
Lordship, may I see the,
No,
when the next
go through it. Go
next time it is hard, because it's a translated portion, something might be there in the vernacular.
Okay, okay. Okay. Go through it. Next Tuesday, well, আজকে তালুকা কতটা আপেল and give me a senior
Please take a
Tuesday.
please.
on Tuesday.
Lordship, can it be 29? Monday?
29th is good.
On 1st of May?
But on 29th division, by 2
On 1st,
o'clock,
1st of
so he you have any difficulty?
30th, another matter has been fixed, poll 2018 matter, before another court.
We'll accommodate. but
Lordship, my lord,
we have difficulty on
my
past
lord,
or
lordship.
I do not remember.
The-
Anyway,
Prosecution witnesses were not examined. Witnesses cited as prosecution witnesses, they were cited as defense witness.
okay. We'll have to somewhere in the next week because there will be breaking up of this division. Seventh election.
Election, holiday.
So post-election, maybe in the week commencing from 13th of May. Fine. Right. Appearing for the petitioner,
My lord responded.
respondent. Comma, with the council, with the consent of the learned council for the petition.
Fine.
Has made prayer for adjournment of the case for the day. The prayer.
Deeply. May it please your lordship. Lordship, with the consent of the other side, I beg to mention item number 18 of today's daily list.
18.
18, lordship.
Okay, you are
I am D. Roy.
B. Roy.
D. Roy on behalf of T.H. Hazarika.
18 is connected with 19 also.
Your lordship.
You are for the petitioner.
Petitioner, lordship. I have
Okay.
informed the other side.
On the prayer of Mr. B. Roy, learned counsel appearing for the petitioner. Comma, which prayer is made with the consent of the learned counsel for the respondents. Comma, the cases are passed over for the day.
Obliged.
May I please, Lordship? Lordship, I beg to mention item number 15, Lordship. Lordship, my senior is out of station now, Lordship. Kindly adjourn for today, Lordship.
On the prayer of Mr.
B. Chakma, Lordship.
B. Chakma,
Lord.
learned counsel for the petitioner. Petitioner.
Lordship, interim order to be continued, Lordship.
You wait then. We'll see. No, please. First, let us get over with the bills. Any other prayer?
Also, I beg to mention item number 23 and 24, with the consent of the other party, the matter may be adjourned for 2 weeks,
Or day or what?
2 weeks
2 weeks.
after
You for the petitioner.
respondent number 1.
Mr.
A. Ahmed on behalf of Ahmed Chaudhary.
Your name is appearing.
A.
A. Ahmed.
Ahmed, Azad Ahmed.
On the prayer of Mr. A. Ahmed, learned counsel for the respondent number 1. From which prayer is made with the consent of the learned counsel for the petitioner and other. The case, sir. Adjourned for
May I lordship? May I lordship? Lordship, item number 17.
Uncle, who made the prayer? Interim order, if any. Welcome. Huh? And not it. On the prayer of Mr. B. Chakma. The case and adjourned for a week. Interim order, if any, shall continue.
May I please, Lordship? Lordship, can you,
Interim order, if any, I am not checking the file. Interim order, if any, shall continue.
my lord, and Lordship, if this matter, if kindly fix on second May, Lordship.
Will not fix anything.
Second or third, Lordship, because the lower court matter fixed on fourth May, Lordship.
After we come.
Lordship, in the lower court, evidence part is going on, Lordship, at this moment.
Uh,
So if kindly, Lordship,
Interim order is that the trial
yes,
court
adverse
shall
orders,
not
no,
pass any adverse order.
yes, Lordship.
No
but
stay.
no stay, Lordship, yes.
No stay.
Yes, no stay, Lordship.
Shall not pass any adverse
Adverse
order.
orders by the
Trial
side
may
court.
go on.
Trial may go on, Lordship. So next day is on fourth, Lordship.
That is not subject to any order.
Look.
Adverse order shall not.
Adverse orders.
Meaning
Lordship.
thereby final order, if it is found to be adverse, it cannot be passed.
And Lordship,
Trial will go on.
yes, Lordship. If Lordship kindly fix on second or third
We
May.
will not shortcut the trial after a week. Yes. Interim
Okay.
order is extended.
Obliged.
May I lordship, item number 17. Could we please with the matter to be
Hmm?
passed over? Item number 17, your lordship. Could we please with the matter to be passed over? Already we have taken the consent.
These are order. Okay. On the prayer of Mr.
I am saying on behalf of P.K. Roy Chaudhary,
Mr.
Saurabh Kashyap.
S.K.
Kashyap.
Kashyap. Learned counsel appearing for the petition. Appearing on behalf of Mr. P.K. Roy Chaudhary, learned counsel for the petition. The case is passed over for the day.
Lordship, there is a connecting matter, it is supplementary item 25.
Item number 20. Number 20. Yes.
Lordship, I beg to mention for listing of a criminal petition. Lordship, matter was last listed in the month of August of 2023, Lordship.
Hmm.
Lordship, if possible, Lordship, if not incoming this week, Lordship, on Friday.
Not this week, next week.
No.
Orders for order.
Order. Deeply.
May I please, Your Lordship? I beg for listing of IX minute in connection with appeal against the conviction. It was last listed on 19/2/2024, and after thereafter it was not been listed anymore. So and it was also directed to be listed after 2 weeks, but it was not listed yet.
Okay, next week.
So
I beg to mention item number 2, Lordship. As per instruction of the party, we are withdrawing the petition, Lordship.
Mr.
N.Z. Chaudhary
N.J. Chaudhary.
on behalf of Mr. A.R. Bhair.
Yes, I'm the respondent. Have not been issued a notice or anything. And if they're withdrawing, that's fine. Otherwise, I want
They're
to.
withdrawing.
Lordship, we are withdrawing. There have been some defects in pleadings and
Learned.
it's not enforced.
Counsel appearing for Mr. A.R.
Bhair,
Bhuiyan.
Lordship.
Learned counsel for the petitioner has submitted, on instruction, that the petitioners want to withdraw the criminal petition. Full stop. You want your name to be recorded or what? Your name?
A side.
Okay.
Respondent in person.
MS A. Soikia. Learn it. Comma. No, another here. Another.
Respondent number 1.
Respondent number 1 in person. Is present. Respondent number 1 is present in person. In view of the above submission made by learned counsel for the petition, the criminal petition and
Lordship, may I kindly give liberty if need.
Liberty would not be necessary if it is connected to item number 22.
Notice has not been issued. You have not been
Yes,
given any right
fine.
to audience.
That's true.
Just because you have appeared as a
As in person.
responding person, we have recorded your notice has not been issued.
No.
Court has not taken any cognizance
Much obliged.
for liberty.
But we would like to mention item number 16. This is IA for condemnation of delay. The respondent was granted time to file objection. In fact, I have received a copy of objection yesterday, which is also not on record, Your Lord. I don't.
Mr. M.H. Oxford, learned counsel for the applicant petition, has submitted that the private respondent number 2 has filed an objection to the interlocutory application yesterday, and copy of the state interlocutory application is served to him only yesterday, as the state objection is not tagged with the case record from he has got from the case. After
Any date
the
possible,
praise
Your Lord?
allowed, is the case.
Any date, Your Lord.
Sure.
Obliged.
I have a small prayer for listing law. The criminal petition we have filed yesterday, Lord. It was yesterday itself. It was numbered. The case is not there in the daily list tomorrow, Lord. Only difficulty on my part is that after tomorrow the case is fixed portal under trial court. Can it be tomorrow, Lord, in the supplementary list? I have approached the registry. The registry suggests me to make a pension.
Yes, sir.
Lord.
May I please? Number 439 application number.
Yes.
FIR is at my lord 7 XR 1. In fact, my lord, petitioner was arrested in another case. My lord, he has been put in arrest in this case on 28/3/2024. FIR has been lost by my
Okay.
lord, one.
Purchase of land on the basis of alleged force
My lord.
sale deed.
My lord.
Let us have the case there.
Yes, Lordship, there is a connected matter, item number 12.
12.
So that in that matter, Lordship, CD was called for, that is not received.
Not received.
Yes. Check to that.
So
It is 439, that is
what should be the proposed date for the
Lordship,
other date, other case diary?
Can it be on third or
Third of.
from Bokush number.
So if that is not coming, your case will not be coming. Heard Mr. J. Islam, learned counsel for the accused petitioner, and MS S.H. Bora, learned additional public prosecutor for the respondent. Date of serve filed its application 439 Bokisto Police Station 188 2024. Mr. Islam has submitted that the petitioner has been shown arrested in connection with Bokisto Police Station case number 188 2024 when he was in custody in connection with that is not there. Huh? In connection with which police station case number?
In connection with my lord, case number.
Hmm? Bokisto Police Station case
Yes.
number 43 2024.
Yes, Lord.
Police the case on 3rd of May
Third of
2024 for production of the concerned case diary. Who is the petitioner in item number 12? 12? 12. You?
Yes.
Okay. Heard Mr. J. Islam, Learned Counsel for the petition, and MS Satish Bora, Learned Petitioner, Copy for the respondent state of Assam. MS Bora has submitted that the concerned case diary is called for has not been filled and called for listing of the case on 3rd of May
Yes.
2024 for production of the concerned case. This is the case accordingly on 3/5/2024 for production of the case diary.
Yes, yes. 439 application.
Yes.
Yes, diary receipt.
FIL page 7. 27 long of Onasoli wine recovered from the petitioner. That is the case of petitioner vehicle. Yes, sir.
Yes.
Yes, my lord, he admitted everything that he is doing this business, my lord, things long. That is my lord.
House is near loss of Onasol.
Custody required.
Custody required, my lord,
These are made, is made already.
20 days behind the birds, my lord, yes. Otherwise, my lord,
What is the
370.
value of this?
Yes,
Otherwise,
yes, yes.
total value of this is a material.
Value maybe, my lord,
Whether investigation will be hampered, he is released on bail.
investigation is going on, my lord, only that he may repeat that business, my lord, again, my lord, that is doubt. Because he is a veteran and doing this business, my lord.
Any antecedent?
That is only his statement.
That is otherwise not going to that aspect. Third, Mr. L. Gogoi, Learned Counsel for the accused petitioner, and Mr. B.B. Gogoi, Learned Additional Public Prosecutor for the respondent state of Assam by this application. In the first information report lodged by an assistant sub-inspector of police attached to Alem listing on 3/4/2024, it was entirely alleged that on receipt of an information from reliable source, one vehicle within bracket Tata Punch, one vehicle within bracket Tata Punch bearing registration number AS-32/B-0771 was intercepted, as the information was to the effect that the vehicle was carrying IMFL
I'm from Arunachal.
from Arunachal Pradesh by way of smuggling. Full stop. Accordingly, the vehicle was intercepted at a Naka checking point at Mara Stengelijan by a police team, and on making a charge, liquors is 13 in packet liquor manufactured in Arunachal Pradesh were seized, were found and seized, and the petitioner was found in the said vehicle. Full stop. The on being asked, the petitioner could not produce any valid document in respect of the IMFL liquor items, allegedly manufactured in Arunachal. Para. Mr. Gugoi learned additional public prosecutor. On the basis of the materials available in the case diary, has submitted that petitioner is suspected to be involved in the illegal trade of liquor manufactured in Arunachal Pradesh, in the state of Assam without valid documents. First of the investigation of the he has submitted that the investigation of the case is in progress. First of. On the other hand, Mr. Gugoi and counsel for the petitioner, accused petitioner, submitted that the alleged illegal liquor items have already been seized, and as such, further detention of the accused petitioner may not be necessary for the purpose of carrying out further investigation into the case. So he has submitted that since the petitioner, accused petitioner, is a resident of Vishwanath district having no criminal antecedents. There is a resident of- permanent resident of Canada having. I have gone through the materials available in the case that he collected during the course of investigation date. Also part full stop. The alleged illegal MFL items have already been seized. Full stop. The accused petitioner after arrest, was produced before a learned court on 4/4/2024, and since then, the accused petitioner is in custody. I have the considered view that the court is of the considered view that further detention of the petition for the purpose of carrying out investigation in the case appears not necessary if the accused petitioner extends his assistance and cooperation in the further investigation of the case. 25,000, one COT to the satisfaction of
SDGM, Gopur.
huh? SDGM,
Gopur.
Subdivisional Judicial Magistrate, Gopur, Vishwanath. 1, 2, 3, 4, 5.
Apply.
Made it. It's a 439 application. FIR is page 13. In FIR, my lord,
13.
yes. All sections are, my lord, registered. My lord,
Recusal.
punishment is, my lord, less than 7 years or up to 7 years.
To inform you that 12/1 a request for pertaining to appointed state person in political meeting. There was a So one Zina Soikia submitted an application for
Yes,
police verification report
yes, my lord. I am
on the
positive.
basis of an appointment letter issued by Oil India Limited, right? So during verification with the Oil India Limited, appointment letter was found forged, right?
Yeah.
So accordingly, FIR was lodged. Now,
Yeah.
how this petitioner is connected?
Yes, sir. I am Subhajyoti Dwara.
Petitioner is what? Who? Who is the
Subhajyoti
petitioner?
Dwara, my.
Subhajyoti Dwara.
In forwarding report also, my lord,
Hmm.
brief of the case, my lord, against Rina Soikia, my.
Hmm?
Forwarding report also, page 17, my lord.
Page 16.
16 is, my lord, and
Mhm.
17 is relevant person.
No, why you have been arrested then?
Yes, my lord. In connection, my lord, they have suspected that I am also involved in it.
Part of the huge racket.
And my lord, 41A CRPC notice was also not served on me. All sections are, my lord, to up to 7 years.
Yes.
Yes, that Rina Soikia 164 statement recorded, madam. She implicated this person, madam. She collected that 7 lakhs rupees and give it to Subhajyoti, the present petitioner, madam. Present petitioner, his 161 statement also, he admitted that he has taken that 7 lakhs rupees from the informant. That is there. It is different.
Parthan. seeking appointment in Oil India Company,
Yes.
Oil India Limited, procuring an appointment letter from a private person is complicit with the knowing very well that her appointment letter is forged, yet applied for.
Without interview, without interview.
If such caliber person is available in the society, very good. Everybody will procure appointment letter and seek appointment. I wonder why educated persons obtain such kind of appointment letter. Very easy prey for them, this kind of person.
Yes.
Type it, give it, 7 lakhs. Anything?
And that is admitted. He admitted that I have taken money.
No, that admission will ultimately
That,
will have no value.
trial it
But
is,
anything more, anything more,
no, at this stage, my lord, this is
that is all. Jina Soikia said,
Gina
Jina said,
recorded.
I got the certificate from
Yes,
this man
Dhruva.
in exchange of 7 lakhs.
Yes.
That's all.
Yes.
And anything from Oil India Limited?
No.
No.
They have not made inquiry. I think I got that. Only
Third, Mr.
M. Kolita.
M. Kolita, learned counsel for the petitioner, and Mr. P.V. Gugoi, learned petitioner, public prosecutor. 439. Tinsukia Police Station case number 92 2000. 1. Yes, Mr. Gugoi, what is this? Page 12. What is this digital warrior? Interesting name. Informant. Below.
is
Page 13. Below his name, digital warrior.
name and address of the accused. As per the
No.
response.
Yours faithfully. Page
Faithfully,
13.
Yes. Passport 130 passport.
Digital warrior. What is this?
Maybe address something.
Not address. How can it?
Digital warrior, I do not
Very
understand.
interesting reading. See?
Yes, I
See?
do not understand. Digital warrior.
His
Tinsukia Police Station.
designation,
Designation is warrior.
It's all right. It
Okay, very good.
digital warrior.
Okay. We'll record that. The first information report. In the first information report lodged by 1 EBC as digital warrior, Tinsukia Police Station, it has entirely been alleged that it has entirely been stated that on 12/1/2024, a request for police verification report in respect of 1 MS Zina Hoikia was received. Full stop. Such police verification report was sought for on the ground that Messrs. Oil India Limited Duliajan has issued an appointment letter under the hand of its chief general manager within bracket HR Acquisitions, Oil India Limited, Duliajan. Full stop. Such application for police verification report was made through Assam Police Sewa Hetu online official portal. Full stop. When an inquiry was conducted, the appointment letter issued in the name of MS Zina Hokia was found to be a forged document as Messrs. Oil India Limited did not issue any such kind of appointment letter. As the appointment letter was found forged, the FIR was lodged. In the course of investigation, the accused petitioner was apprehended and was produced before the court of Deputy Magistrate in India on 3/4/2024, and since 3/4/2024, the accused petitioner is in custody. The allegation against the accused petitioner is that he might be a part of an alleged racket, which is involved in issuance of fake appointment letters, orders. Whereas, while Mr. Kulital and Council for the accused petitioner has submitted that the accused petitioner is not named in the FIR and he is not connected to the alleged issuance of alleged forged appointment letter. According to him, the petitioner has been arrested merely on suspicion, and the procedure prescribed in section 41A, was not followed. Mr. Gogoi is based on the basis of the material report. Ms. Dina Soikia in a statement stated that she collected the appointment order from the accused petitioner in exchange of a sum of rupees 7,50,000. I have heard the counsel for the parties and it was in the case that the allegation against the petitioner is that he was instrument in issuance of the appointment order under the shown to have been issued under the hand of an authority of Oil India Limited in favor of Ms. Dina Soikia. Having considered the nature of the allegation made in the affair where the accused petitioner is not named. And considering the period of detention of the petition, I want to consider you that for the purpose of carrying out further investigation into the case, custodial detention of the accused petitioner is not necessary provided he continues to extend assistance and cooperation into the further investigation. So 50,000 once yearly.
CGM 300.
CGM into 1 to 3
Lordship, on the last occasion, your lordship directed me to obtain instruction whether charge sheet has been filed against all the accused person. I telephonically obtained instruction, verbally obtained instruction, my lord. It was filed against my lord, the persons as and whose name has been mentioned in the bill application 2509, as well as the next item.
2509.
Yes, 2509.
We can close then.
Yes.
without the absence of the
Yes,
in
your lord.
absence of the petitioner also.
It can be done. Last occasion they appeared today. They
Uh, the two petitioners, three petitioners, VIJ 1, 2, 3, have approached this court by the instant application,
number.
instant 3 years bill application, instant application seeking the privilege of 3 years bail under section 438 TRPC in connection, apprehending arrest in connection with Obhayapuri Police Station case number 318/2023, registered for the offense under section 498A, IPC. So, the first information report in connection with Obhayapuri Police Station case number 318/2023 was lodged naming 4 persons as accused. The present 3 petitioners are named in the said affair. The said affair was lodged by one Halida Parvin, wherein her husband named Ijaz Ali Khan has been made accused number 1. When the application was moved on 21/7/2023, the petitioners, the present petitioners were provided interim period bill with a direction to appear before the IO of the case
Is there?
within a period of 10 days from 21/7/2023. Post of Mr. N. Ahmed, learned counsel appearing for the petitioners, has submitted that the all the three petitioners, pursuant to the interim order dated 21/7/2023, appeared before the IO of the case and joined the investigation. Where MS Puya, learned senior consultant divisional public prosecutor Assam, has submitted that after completion of investigation in connection with Soyapuri Police Station case number 313/2023, the investigating officer of the case has already submitted a charge sheet under section 173(2) CRPC by charge sheet number 285/2023 dated 31/7/2023. In the said charge sheet, MS Bhuya has submitted that instruction has been received
Telephonic.
over telephonically to the effect that none of the present three petitioners has been charge sheeted.
No, all are searched.
Has been okay.
All
All
of
the
them.
three petitioners have been charge sheeted. Where is the other one?
Next one.
In husband,
Ijaz Ali is item number 10.
husband,
So there was interim.
yes,
Interim order. Okay. Interim order 21/7 years. Same thing, 10 days. Practically for the present the petitioners are in-laws of the informed. It will give the present petitioner is the husband of the informed. As pursuant to the interim order dated 21/7/2020, the petitioner appeared before the IO of the case and joined the investigation. Wherein after the IO of the case, after completing the investigation, we are extending
It's the interim order. Till they enter
till the entire appearance.
in the trial.
There is no necessity. They have appeared, they have joined the investigation. Thereafter, you have submitted.
Maybe
the
they have
charge.
appeared. I have no instruction.
They recorded, otherwise, why they- otherwise they do not submit.
Right.
Yes, what to do? Who
Charge
will,
sheet has been filed, my
Huh?
charge sheet. Number 75 will be called.
there is no representation on behalf of the petitioner on call. The present applicant. The petitioner was extended in time by an order dated 22/8/2003 with a direction to appear before the IO. Within 2 weeks from 22/8/2003. MS Bhuya, learned in a consideration of obligator and submitted amount instruction. I have the case after completion of investigation. I have submitted in connection with Moran police station case. Right, but
75 of 2023, dated 31/10/2023. On the last occasion, sir, they did not appear, ma'am.
it is found that in the application of previously on 9/4/2020, none appeared for application. There is no representation on behalf of the we also non-representation on two occasions. It appears from non-representation from other application. The instant accordingly command
May I please, your lordship, pursuant to the earlier order, lordship, correct record was received today, lordship. Matter may be listed for hearing. Earlier occasion, wrong record was
criminal appeal.
criminal appeal against conviction, lordship.
Ms. Bora, find out whether office notice correct 20/04/2020. Because earlier a wrong record came. Then again, the correct record was called for.
Got
Whether the wrong record earlier called for is still with the DSM because it has to be returned.
Got
Record. One of the records may have to be sent.
Got
Find out whether it is correct.
Yes.
On a cursory look, I have found
Not.
Lordship, may I please? Is an application under section 482 for quashing of the FIR and charge sheet. My FIR is at page 16, Lordship.
why it has come for orders. Please answer.
Lordship, I have steps has been taken.
Have you gone through the record?
Yes, steps taken on 30 on as per record 13/8/2023. Notice sent to the respondent and from the lower court scan copy of the charge sheet has also been called for.
What is the case about?
It's a street vendor was at Megdud Bhavan.
No,
He
no,
did-
no.
Actually, it's a
No, sir, actually, ever
Uh-huh.
you are in NDPS or
Yes. 20B.
no, I am asking you,
Yeah.
you are involved, found allegedly involved in NDPS.
Lordship, correct.
You are the sole accused?
No, 3 accused.
Huh?
3 accused.
Right? No, I am asking.
Yeah,
I am asking for a reason. Because I have asked him to go to the record why it has come for order. Right?
Yes.
Now, your alleged partners in crime perhaps moved the sessions court. That is why scanned copies are not received.
No.
All the records are in the session court.
Lordship, may I please?
plus service report, no such person found in the address, return to sender. So none of your submission is found accepted. Service of notice could not be affected because there is no such person in that address and the notice had been sent back. Secondly, there is a communication from the Chief Judicial Magistrate Mr.
DJ Deka. Lordship, I want to say that fact.
Learned Counsel for Appeal. What do you want?
In the session court, I am also the facing for the trial. I am for the in the trial. I am doing that in the session court. There are three accused: Vikas Burman, Vipul Deka, and one Shekhawat. Shekhawat is from Rajasthan. He is not appearing. My case is that Vikas Burman, he was a strict vendor in Meghdut Bhavan.
Mr. Counsel,
Lordship.
why you have made respondent to a party?
It's an informant. Means for a criminal petition to be heard, the informant.
So you have to take complete the step.
Lordship.
How long you are practicing, Mr. Counsel?
10 years.
How long?
10 years. 10 years.
So the submission you are making for a quashing petition without the record, without the service affected upon the response number 2.
I have taken.
Taking steps is not there, not the only step. There are many things to it. Service is to be affected also. I have asked you at the very first point of time, have you gone to the office notes?
On 13, as per on 13/8/2020, it reflected the steps.
Have you gone to the office notes? Why you are making such submissions? There is a big office note here. Service could not be affected upon the response number 2 informant because there was no such person like that. Return to sender. On the pair of Mr. DJ Deka, Learned Counsel for the petition. The case is passed.
Okay. First step maybe.
Mr. Counsel, first you go through the office notes. That is the minimum requirement we have learned. Right? Don't waste the time of the court. I had asked at the very first point of time why it has come for orders. Am I clear? You have been making submissions on merits. Right? It has to be sent back. Record.
He has got the both files are there. Both the files
are there. One is my lord connected with present case, another is not connected.
Right.
So
This
that,
one.
that file may be.
Which one?
Yes, I have shown it to Mr. Doctor.
Heard Mr. ABT Hawk, Learned Counsel for the appellant, and MS S.H. Vora, Learned Additional Public Prosecutor for the respondent number 1, state of Assam. So, in view of the office dated 24/2024, office to send back the case records of sessions case number
117.
Sessions,
T1.
sessions within bracket T2.
T2 is connected.
T2.
T2 is connected our case. T1.
T1.
Has to be
T1
sent
is
back.
not connected.
T1 has.
T1
Yes, judgment.
Sessions within bracket T1. Case number 117 within bracket capital N stroke 2014. And what is your pair on the merit?
Dear Lordship, matter may be listed for hearing, Lordship. Earlier occasion, we have filed a miscase for early hearing, which has disposed of
Any private respondent?
private respondent is there,
Huh?
Lordship. Informant is there.
Served or not served? Offense under?
326, 34 APC. Conviction is for 10 years, along with fine of rupees 10.
Any service of notice?
This is awaited.
Any direction to issue notice? Second case for issuance of notice. Service report. However, it appears from record service report of the notice issuer has not yet been returned. Returned. Let the matter be placed before the law Jima court. We are starting the service of notice under the number 2, which was sent by registered post on 19/8/2023, and this the case they have bill thereafter with a report of then we'll fix it for it. Yes, anything positive?
Challenging the order is 13/3/2000.
Mediation, result of mediation. 15 days time. Mediation.
And I have a my lord, the petitioner has filed a case before the Supreme Court of India regarding stay of the proceedings of the TV case.
So we are dealing with what case? 18 Mitchell and Ananta.
This is with respect to order dated page 42, your Lordship, 13/3/2020.
Case 40. Nitin Mitchell, Uma Mitchell. They are what?
Husband and mother-in-law.
Huh?
Husband and mother-in-law. The domestic violence case was settled.
Husband and mother-in. Okay. So
Okay.
against this order, you have
Filed this petition.
petition. Then, if you are, who has approached the Supreme Court?
The
Not-
petitioner,
Petitioner.
the petitioner,
Petitioner. If you are approaching the
I am not aware of it, Your Lordship.
Supreme Court, then why you are agreeing to a mediation process at the same time?
I am extremely sorry.
Why
I-
two-pronged approach?
I apologize, Your Lordship. I am not having the instructions. I have to take instructions.
Any information, let us get. See, both you cannot do.
Yes, I understand, Your Lordship. Definitely. I will have to take instructions.
You cannot buy time in mediation process
True.
and approach the Supreme Court to get a stay order.
I understand.
Huh?
I have to take instructions, Your Lordship. I am not aware.
Any order passed?
I have no knowledge regarding,
Huh?
I have no knowledge regarding the order.
Transfer petition
That's a different thing. That's what-
or proceeding?
Yes.
No,
I am telling
has
you
some
so-
hearing.
Yes, definitely. I will take instructions. I am not aware of this proceeding, Your Lordship, the Supreme Court.
Where you are seeking what? This there you are taking transfer because it's the incident according to them occurred in Delhi. You know. So they filed a case in Assam. From Soraideo and Sunari to Karkar Duma Court, Sahdora. Third, Mr. T. Deuri, Learned Counsel for the petitioner and MS.
Puri.
Z.
Puri.
Puri, Learned Counsel for the
Respondent number 2.
respondent number 2. Also heard MS Stage Bora, Learned Counsel Public Prosecutor for the respondent number 1, State of Assam. By an order dated 5/12/2023, comma, the matter was directed to be placed before the mediator of Guwahati High Court Mediation Center on the submission of the learned counsel for the parties that there is a chance of reconciliation between the parties. A letter of the mediator is placed on record whereby the mediator has sought further 15 days time to settle the mediation process. So, MS Puri, learned counsel for the respondent number 2, has submitted that information has been received to the effect that the petitioner's hearing have also approached the Honorable Supreme Court of India by instituting a transfer petition under Section 406, CRPC, which transfer petition has been registered and numbered as transfer petition within bracket criminal number 843 of 2023. By the state transfer petition, the petitioners have sought transfer of the proceedings of the complaint case Miss within bracket DV case number 03/2020, presently pending before the Court of Learned Subdivisional Judicial Magistrate Soraida to Karkar Duma Court, Sahdora, Delhi. In view of such submission made by MS Puri, Learned Counsel for the respondent number 2, Mr. Deuri, for the petitioner have submitted that he has no instruction in this connection and has sought for listing of the case for 2 weeks to obtain complete instruction. So, having regard to the request made by the mediator and Mr. Deuri, learned counsel for the petitioner, let the case be listed after 2 weeks. Thank you.
May I please, Your Lordship?
Service report.
Lordship, for the respondent number 2 appears.
Appears.
Someone appeared.
Okay. Let it be on NBC. Third, Mr.
A.K. Ahmed.
A.K.
A.K.
Ali
Ahmed.
Ahmed. Learned counsel for the petitioner and Mr. Bora, learned counsel. Mr. W. Armedi, learned counsel has submitted that he has entered appearance on behalf of the respondent. So, as the service of notice upon respondent is complete, let the case be listed for admission. After. For question or what?
Receive. LCR receive.
They receive. LCR, sorry, the records of the learned trial court. Don't say LCI, target, AGI, Chief Justice of India. Don't say lower court.
Lord.
So.
Lord.
You say TCR, right? Is that it? Or it-
Obliged.
Yes. Master. Okay. Right. I got to repeat to you, naam kita. Mr. Kyle has submitted a copy of the master certificate. Number. About to assign details before the arguments are heard. Judgment is equal.
Respondent number one on behalf of the state.
For MSK book. Also heard MSK book. Learned central government office for response number one. Right. CKL and training also DSP for response number 2 and 3.
Six, we have taken state's lordship, other side is entered appearing. Service is
Sir.
complete.
S.H. Raman.
S.H. Raman. You have appeared. For response number 2.
We have taken states.